Hi, this is Andrea Kane, and I'm here with you with HIT 421 Legal and Release of Information. We are on week one, and before we dive into our slides this week and do our lecture video, I'd like to talk to you briefly about your syllabus review. Hopefully, you have watched that by now and taken the quick 10-question quiz. If you have not done that, would you please do it as soon as you finish watching this lecture video? Because it has a lot of good information in there that I feel like you need to know so that you and I are on the same page in terms of the course. So please take a few minutes and get that done if you haven't already. If you've already done that, awesome. Students tell me that sometimes they like to follow along in their book while they go through the lecture video. Other students tell me that they like to print out the PowerPoints and take notes on them. You're welcome to do that. Please, though, do not go to campus to print those off. That's not something that is supposed to be done. So if you have a printer at home or you have access to a printer somewhere outside of NICC and you want to do that, that's great. But I understand that that's not an option on campus at this time to go and print those types of things off. But anyway, let's get started. We are on week one. We are covering chapters 1 and 2 this week. This lecture video is on chapter 1. Chapter 2 will follow. If you are looking at your syllabus, you'll notice we're going to be covering unit objectives 9.1.1 through 9.1.16, both this week and next week. We spread those out across those weeks as we go through the first 4 chapters or so. So if you want to take a look at your book and crack it open, we are on page 1. You'll notice that there's learning objectives there and key terms. And if you have looked at content for this week in Brightspace, you'll notice that I mention how important it is to be looking for those learning objectives and make sure that you're aware of those and understanding of those, to make sure that you have memorized the key terms and you understand and can apply those. And then I'm going to encourage you that after you've watched the lecture video and done the reading and done some other studying, make sure you do your check your understanding. And I have posted the answers to those check your understanding exercises so that you're able to make sure that you really understand the ones you got wrong as well as the ones that you got right. So let's go on and talk about the fundamentals of law for health informatics and information management. What is the law? It represents a set of governing rules designed to protect citizens living in a civilized society. It establishes order, provides parameters for conduct, and defines rights and obligations of the government and its citizens. And we'll be focusing a lot on that as we go through here about those rights and obligations. It also is theoretically controls behavior that threatens public safety and sets penalties for disobedience. There are 2 types of law. There is public law and private law. Public law is federal, state, and local government. It defines, regulates, and enforces rights and duties among individuals and businesses as related to government. Private law is rules and principles that define rights and duties among individuals and private businesses. So make sure that you know those 2 types of law, their definitions, and that sort of thing, because you will need it for your quiz. Hint, hint, hint. All right, law and healthcare. Healthcare here in the U.S. is more than $1 trillion business. As you can see from the bottom of the slide, this was copyrighted in 2017. I'm sure if you went out to the internet today, you would see that that $1 trillion is probably inching much more closely to $2 trillion. It is regulated by federal and state laws, accrediting bodies, practice standards, and codes of ethics. Do you remember back in HIT 330 and we covered the fact that federal regulations, state regulations, accrediting bodies like the Joint Commission, all those types of things were involved with healthcare? Well, we're building on that in this class. We're actually going to get deep into that. The reason for the regulation is the goal is to protect consumers and providers by requiring accountability for services and privacy, confidentiality, and security of health information. And let's be honest, it's a mixed bag. The theory is good, the intent is good, but sometimes how it actually plays out is not so good, whether you're talking consumers or providers. And we'll find that as we go through here. It's really important for us in this class to see both sides of whatever topic we're on and to look at it objectively. Has there been any studies performed on this? Is there any data on this? Although we all have our opinions and we definitely want to bring those to the table, we want to make sure that we're not looking at things one-dimensionally or even two-dimensionally. We want to see what all these facets are and what is the interplay between them and what is the influence that comes out of them. And whether that's good, bad, or indifferent, or whether that's based on different perspectives or opinions, we want to all consider all of it. We don't want to be as the law black and white, because as we know in our world there's so much more. So health information, it is data generated and collected as a result of delivering care to a patient. And this is on the bottom of page 2. If you're following along your book, that's where we are at this point. There are lots of uses for health information, but the primary use is clinical care. Please know this. Primary use of health information should be clinical care. There are many secondary uses. That includes public health, which we talked about in HIT 330, population health management, third-party reimbursement and payers, quality improvement, and patient safety. Where we're also going to be involved with health information in this class is looking at it as evidence in legal cases when conflict arises and resolution is sought through the court system. So you need to know primary use of health information is clinical care, what those secondary uses are, and how health information can be used as evidence. Health information is protected under federal law. We have talked about HIPAA. Please make sure that you ingrain it in your mind. HIPAA has 1 P, not 2, only 1 P. In this class, I will mark you off as a spelling error if you spell HIPAA with 2 P's, because it's so important. We in this field are supposed to be experts on HIPAA. And if we can't even spell it correctly, it really undermines other people's confidence in our knowledge and our abilities. So we want to make sure that we're doing it right. So make sure you take the time to double check yourself. HIPAA only has 1 P. So it goes on and it defines what HIPAA is. And this is on the top of page 3 in your book. And it talks about how it's any information. Doesn't matter whether it's oral or recorded in any form or medium, so that includes paper, microfilm, microfiche, electronic, that is created or received by a healthcare provider, health plan, public health authority, employer, life insurer, school or university, or healthcare clearinghouse. Those are the ones who are governed by HIPAA standards. And 2, that health information relates to past, present, or future physical or mental health or condition of an individual. Notice the word individual. That is very key. So health information technology, there's been a push to decrease healthcare costs and improve quality and safety of healthcare. And it has been thought by many that this could happen through the use of health information technology, by moving from a paper-based system to an electronic-based system so that health information can be exchanged, again, to decrease healthcare costs and improve quality and safety. This is very key. I would say this slide is important. So make sure that you know it well, the information on it well. Public and private collaborations are working together to eliminate legal barriers for sharing electronically stored health information. And the reason that this needs to happen and that people are trying to work on this is because each state has their own laws that govern health information. HIPAA was the first federal law, the first attempt by the federal government to come through and basically say, we know that many states have very good health information statutes or laws, And we also know that there's quite a few states that really don't have very good um, statutes or laws or any that are very specific at all about health information. And we want to try and make sure that everyone knows there's a minimum, an absolute minimum of what has to be met in terms of health information for privacy and security. And that minimum is what HIPAA is. HIPAA basically says to state laws, if you are more strict than HIPAA, then your state laws determine what happens. HIPAA says to states with very, let's just say less than ideal and very minimal laws, it says you're not doing enough. And this federal law is now the minimum you have to meet. So if there's a conflict between the state law and the federal law, you always go with the one that is the most strict. And that's why you have to know what your state laws are when it comes to health information. And that's, again, why you see this slide, why people are working together, is because they're trying to come up with ways that health information can be shared across state lines. And this makes a lot of sense. For instance, my family and I, we moved here to Iowa several years ago from North Carolina. And prior to that, my husband and I were in Indiana. And prior to that, I was in Florida. And prior to that, I was in Michigan. So my health information has been in several states, spread across several states. And if I ever wanted to get it all together in one place, it would be a huge challenge because the laws are so different. Another example would be if someone wants to go on vacation. It'll get to be at the point where it's vacation time or spring break time, where people want to go away, to preferably where it's warm and sunny. And if you go away and you're on vacation and you have a medical need, your information is back here in Iowa. It's not necessarily going to be in Florida or Texas or California or Arizona or whatever warm place you are blessed enough to go. So they're working on this to try and eliminate those legal barriers between states that keep the ability to share information that could negatively impact someone's health care. And that's what this is all about. So I kind of jumped ahead with a couple of concepts, but that's okay. We're laying the foundation here. Health information is together, it builds into a health record. And this definition is very critical to know. It's individually identifiable data. Note that, individually identifiable data in any medium that's collected, processed, stored, displayed, and used by healthcare professionals. So what are some types of health records? Well, you may have heard of a hybrid health record, an electronic health record, electronic medical record, a personal health record. What are all these things? Your book does a really good job of laying that out for you on pages 3 and 4. So I'm going to direct you there to read that information. A hybrid record is basically, it's got some paper components and some electronic components. That's why it's a hybrid. Most of those are fading away. Again, you got to remember these slides are from 2017 when they last published the book, and so much has changed in almost 4 years. Most healthcare organizations now have electronic health records. And so the hybrids, although they still exist, especially with older records from prior to going on to an electronic health record, that type of health record is fading away. So I'm not going to spend much time on it. Just, it's important that you know what these 4 are and what they mean. And if you're struggling with the definition here in your book, I would suggest that you run to the back to the glossary, and you can take a look in the glossary. Sometimes the different wording between the book and the glossary, it helps refine what they're really trying to say. And it is here. It's paper and electronic, as I said. It can also include video, film, imaging, microfilm, microfiche, all those types of things. And then the electronic health record. And notice on the electronic health record, it conforms to nationally recognized interoperability standards. I think that's probably the most critical phrase for EHR, conforms to nationally recognized interoperability standards. So this would be like a Cerner product or an Epic product. Those are the two biggest players out there today in the EHR world. And this is within one healthcare organization. And that may or may not be back to the nationally recognized interoperability standards. It may or may not. But a medical record is really localized. An EHR means it's across multiple facilities or multiple organizations. And then the personal health record, this is where you as an individual can have your health record reside, where you can add information to it, update information to it. You can open it for the providers that you want to have access to it. It's different than an EHR or an EMR where the providers or the organization are the one that create and keep the record. The PHR is something you do as a individual, as a person. So we talked a little bit about HIPAA, that it protects health information and health records. And after HIPAA, you can see HIPAA came into being 2002, 2003 was when it went into effect. And in 2009, the HITECH Act, and HITECH is just a part of ARRA. So when you're thinking about big federal regulations, HIPAA is one, and then ARRA came several years later. And within ARRA was HITECH, and that added to and clarified and changed a little bit of HIPAA, updated it a bit. And those are two key laws that you need to know when it comes to health information. And this is on page 5 in your book. Privacy and confidentiality have historically been key components of the patient-provider relationship. And when you think about that, it makes sense. If you can't trust your provider to keep your information private and confidential, you're not going to trust them with a lot of detail or with the fact that you have some issues. You have to have that trust in order to be able to be open. And they need to keep that trust to continue the relationship. So the inherent trust is that your information as a patient will be kept private and protected from unauthorized access. That we trust providers to do that. But having said that, it's really important to understand the nuances or differences between privacy, confidentiality, and security and how those concepts relate to law, whether you're talking federal or state. So what is privacy? It's an important social value. It means a right to be left alone. It's the right of individuals to be protected against physical or psychological invasion or the misuse of their property. It includes freedom from intrusion or observation into one's private affairs and the right to maintain control over certain personal information and the freedom to act without outside interference. It's also the right to limit the disclosure of personal information. That's what privacy is. And I'm going to tell you, for your quiz, you've got to know these concepts inside, outside, upside down. You've got to know what privacy means. Confidentiality, same thing. It is the status accorded, it's a status, notice that. Confidentiality is a status accorded to data or information indicating that it is sensitive and needs to be protected against theft, disclosure, or improper use, and must be disseminated only to authorized individuals or organizations who have a need to know. That is very critical. When you are handling information and you are wondering whether or not to share it with a coworker, or share it with anyone else, you have to ask yourself, do they have a job-related need to know this information? If the answer is no, you don't share it. You don't say a word. They have to have a job-related need to know in order for you to be able to talk about the information and still maintain confidentiality. Joint Commission says it's the protection of that data or information from being made available or disclosed to an authorized person or process. Privileged communication. You will hear the word privileged communication. A lot of times you hear it more in the realm of, oh, that's privileged communication between an attorney and a client, or that's privileged communication that's under peer review. That's a lot of what you hear it used as. But privileged communication is between two parties, and those parties have a relationship where they cannot share that information without betraying that trust. And so, for example, attorney-client, whatever you share with your attorney under attorney-client privilege, the attorney cannot be forced to share. It is protected. Same thing between a husband and wife, a physician and a patient, and a clergy and a parishioner. So it's one of those things where you can't get between the two and force that release of information. Whatever's said has its own confidentiality, and both parties have to agree before it can be shared. So because physician-patient is under that privileged communication, that's what obligates healthcare providers to protect that information. What is security? Security is preventing the unauthorized access, use, disclosure, modification, or destruction of information or interference with system operations in an information system. This is all about electronic. Now, granted, electronic health information. Now, granted, you do need, and we are obligated to secure non-electronic information. Paper, microfilm, microfiche, films, voice files, all of that. Yes, that is required to be secured as well. But when you're talking about HIPAA security is really about electronic health information. And it gives you here the information about that. And let's see, what page are we now up to in our book? We are on page 8. And page 8 does a really nice job of laying out data security versus system security and what those definitions are. So I'm going to refer you back to that. I mean, this essentially just repeats it. So I'm going to send you back to your book for that. And same thing again with system security. So there is U.S. Code on information security. You have to protect information and information systems from unauthorized access, use, disclosure, disruption, modification, or destruction in order to provide integrity, confidentiality, and availability. This slide is very important. You need to know how they define integrity, confidentiality, and availability, and know that that's what this is about. You need to provide those. That's what you're doing, is you're protecting information and information systems in order to provide integrity, confidentiality, and availability. And what that means is you're keeping unauthorized individuals from accessing, using, disclosing, disrupting, modifying, or destroying health information or the systems themselves. Who owns a health record? Ooh, now this is a good question. Long time ago, back in the days and age of paper health records, The ownership of the record was by the business. It's a business record. And it is owned by the healthcare organization or provider. However, the information within the record belongs to the patient. And this is where it gets sticky sometimes for people to understand. Their information belongs to them, but their record doesn't. We can give them a copy of their record, but they cannot have their record itself. The record itself belongs to the organization or the provider. It is a business record, and we'll be talking about that more, but the information within it belongs to the patient. And so that's why we provide copies. We don't ever give away the originals. And so the HIPAA privacy rule granted patients, because unfortunately not every state allowed patients the right to access, view, copy, or amend their record. And that's what HIPAA did. HIPAA did a very good thing here in that it said all states will grant a patient the right to access, view, copy, or amend the record, the information within the record. They can't take it away, but they can do those things. They have those rights. So ownership does not permit providers to share or sell patient identifiable medical information as they wish, because the information within that record belongs to the patient, and the patient has to authorize that, except when law says it does not. Okay, I think my mouse got ahead of me here, sorry. Okay, custodian of health records. Ooh, this is an old title. Back in the day, every hospital had to designate a custodian of the medical record. You were called a medical record custodian. Back when I was starting my career, and I'm going to date myself here, that was the early 90s. In my job as first a manager of medical records and then later as a director, I was the medical record custodian, and I had to go to court. And I was the one who was legally designated as having responsibility for the care, custody, control, and proper safekeeping and disclosure of health records for the organizations that I worked for. I was the one who was the gatekeeper. I was the one responsible for making sure that everything happened as it was supposed to happen, and that I could show, if I needed to in court, how I had cared for, had custody of, controlled, and properly kept safe that record, and the disclosures that we had documented, all the disclosures for that. And that's still true today, whether or not you're talking about an electronic health record. That still is a responsibility that usually falls within the Health Information Management Department and its leadership. Stewardship is similar to custodianship, but it goes beyond that physical record to include ensuring integrity, which means accuracy, completeness, and timeliness, as well as the security, again, protection of privacy, as well as from tampering, loss, or destruction. And that's within that electronic information world. If you're hearing a noise, it is my cat, and she is sitting on my desk purring while I am trying to record this lecture. So I apologize for that. I have 3 cats, and it seems like they never come up until I'm in the middle of recording or in a Zoom class or meeting. I've had 2 of them photobomb me today. All right, so moving on. You still have it. Custodianship was back in the days of paper records. Now it's called stewardship. Information governance. We're going to touch on this here in this class, but you actually have a 1-credit class on information governance currently in the curriculum. I don't know if that's going to change, but we touch on it in a couple of classes, and this is one of them. Stewardship as a component of information governance, which is the strategic management of enterprise electronic information, including the standards, policies, and procedures for access, use, and control of that information. So information governance has as a component underneath information governance, think of that as like the topic heading. Underneath that, one of its components is stewardship. And so that is making sure that we are following standards, that we have policies and procedures that govern the access and control of the information. The role of the steward requires leadership, responsibility, and governance to ensure consistent application of and compliance with policies across organization-wide distributed information systems. That is so true. I've worked for large healthcare systems. I'm talking the last large one that I worked for in North Carolina was part of a 36 hospital health system. And so you can imagine that there was a lot of this across organization-wide distributed information systems, and making sure everyone was on board, that they were consistently applying, that they were compliant with, that the policies were updated and they were disseminated and people were trained on those. You can imagine what a role that was. Thankfully, that was not my full-time day job. I only had a small segment of that large healthcare system to make sure that that happened the way that it needed to happen. But that is part of information governance. And that is it for chapter 1 in terms of slides. And custodian of health records and stewardship and health information governance are on pages 9 and 10 in your textbook. I will be back shortly to talk to you about chapter 2, which is the last lecture video for week 1. So take care and have a great week.